Ladies and gentlemen, we have a really topical panel coming up, led by none other than Margaret Rosenfeld of the law firm Smith Anderson. Ladies and gentlemen, Margaret Rosenfeld.
Thank you, Shelley, so much. Excuse me, I have someone's extra papers up here. How many were in for the prior panel in the room? Okay. How many folks in the room are a public or a private company? Raise your hand. Okay. Keep your hands up. Keep your hands up. Public companies, take your hands down. How many private companies? Okay. So we're just trying to get a sense of who's in the room right now. How many out there are investors, funds, etc.? And then the professional advisors in this area? Okay. So that we like to give the panel a little feel of who's in the room for our panel. The panel that you just sat through was pretty incredible to get that insight into what they're looking at, what the criteria they look for. But many of the companies probably in this room and at this conference are not yet there. If you heard the $2 stock trading, I would say this conference tends, just so you're not feeling overwhelmed, this conference tends to be targeted at the companies that are working to grow to get there. And so this panel will discuss a little bit about, well, how do you grow to get there, and how do you find that money to get to that stage? If you're a private company, where are we seeing money come from right now? Or if you're a public company, you're a life sciences company, and you're in the clinical trial stage, and you're just getting there, how do you avoid that debt that they were talking about that they don't like? Is that possible? So we're going to talk about that a little bit. The MicroCap market, when you looked at it last year, and we're going to talk a little bit about what we saw last year, because that informs us of what we believe we're going to be seeing this year. But the MicroCap market last year was stalled until the election. That was most of the capital markets were stalled until the election. And then after the election, the MicroCap market actually took off. You saw sort of this inhibited environment open up. The question is, are we going to continue to see that? So there are experts out there who are saying we're going to see retrenchment, there's valuations that are too rich out there, it can't continue. The things that influence that are going to be things, what's going to happen with the corporate tax? That's going to be a big, what's going to happen with the interest rates, repatriation regulations, deregulation, increased spending on infrastructure in the U.S. All of these things are what we're going to see impacting this market. And right now, probably most of you have out there for the first quarter have seen a little kind of freeze from what we saw kind of wake up after the election. So now we're going to talk about, in this panel, last year was kind of an anomaly because we had that strange pre-election, post-election. Are we going to see a market pause now to digest what's going on? Are we going to see some headwinds, or are we going to see some tailwinds? So we're going to talk about that a little bit in all of this. I know the last panel talked about hating debt. I think we'll talk a little bit about that. They're talking about reverse stock splits and are they bad? We're going to talk a little bit about that. So who do we have here today? These are the folks that are in the trenches with these companies, private and public companies. And they're in the trenches, and they're trying to figure out how to help them find the financing and how to help them grow. So I have asked each of them to give their 1-minute elevator speech of what they do. All of us are attorneys. I would say all of us probably fall into a different category of attorney than you're used to. These are attorneys who are probably 70% legal advice and 30% business advice from the types of clients that we deal with. So I will ask Lance first, if you could introduce yourself.
Sure. Thank you, Margaret. Lance Kimmel, SEC law firm in Los Angeles. I'm a former big law attorney, New York, Silicon Valley, and Los Angeles. And then as we were building out of the dot-com implosion, some very senior colleagues from other name law firms and I decided that we loved what we did. We didn't necessarily like the environment in which we were doing it after so many years, and so we wanted to do the same thing our way and also provide services that are a little bit more price beneficial to growing companies. So we represent companies that are private, going public, are public, in their financing, M&A, and other corporate growth transactions. Secondly, we represent investors, including funds and fund formation, lead investors. And thirdly, we represent regulated professional advisors in this industry. That includes investment bankers, auditors, and even other law firms, so that when they get a nasty letter from the SEC, FINRA, or the PCAOB, who are you going to call? Our clients, despite being a small law firm, are global. I love to rack up frequent flyer miles that I can't use. So our clients are primarily in the United States, but also Western Europe, China, Korea, and India.
Lou?
Hi, I'm Lou Bevilacqua. I've been a corporate and securities lawyer for the last 20-plus years. Like Lance, most of that time I was at large international law firms. I was a partner at Pillsbury, Winthrop, Shaw Pittman. I left Pillsbury in 2013, started my own firm. It's a boutique corporate and transactional firm. Most of the people there are from, large law firms. We focus on representing entrepreneurs, ranging from a couple people in a garage as a startup company to companies listed on the NASDAQ Global Select market. We represent about 15 public companies and over 40 private companies in different stages, and we also have a very active China practice.
Good afternoon. My name is Lazarus Rothstein. I'm a partner at Legal and Compliance. We're a corporate and securities law firm representing companies in a full range of SEC reporting and corporate transactional work. Just a little bit about my background. I've been practicing for about 30 years, mostly in-house corporate counsel for some large New York Stock Exchange and NASDAQ listed companies. And about 5 years ago, I joined Laura Anthony, who's the founder of Legal and Compliance, in representing companies that are going from private to public and the smaller public company arena. A combination of Laura's technical and legal skills and my background in transactional and securities work, we bring a pretty well-balanced approach to taking care of our smaller clients that can't afford in-house counsel. And like the other attorneys on the panel, we represent both the public companies. We have about 55 or so public company clients. We represent family offices on the investor side, hedge funds, and the like. So we have a broad-based practice as well, mostly U.S.-based, and we're starting to see an uptick in international transactions as well.
All right, and I get to introduce myself last. I am based out of Research Triangle Park, North Carolina. It's named that because of our universities there, Duke, UNC, NC State. It forms a triangle. Our law firm grew there based on startups spinning out of those universities. So over 100 years ago, our firm was founded. And we cut our teeth on those startups. But those startups become Red Hat, Quintiles, Cree, all of whom we represent. So we have this great array of startup to large public company work. I personally started out first in the Tokyo office of Paul Weiss, and I, for the first 7 years of my career, did large IPO, mostly cross-border IPOs. Worked in Tokyo, then worked in London and Frankfurt for a firm called Freshfields Brookhouse Deringer. I ended up going to the Research Triangle Park because I was tired of the work for a company, do their IPO, move on, and not having that ongoing general counsel-like relationship, which is why I became an attorney. My father's business was the first business I sold. And that influence of those attorneys was what I wanted in my career. So I looked for a region where I could do that. Most of the clients that are public that I work with have no general counsel, and I serve the role of their general counsel. And so it's not just financings, it's this contract came abroad, we need to do a distribution agreement, a license agreement. Oh, I just got sued for something, sexual harassment. So we do all of that. I have the pleasure of working on these really large clients that keep the lights on in our office, but the real pleasure comes from working in the microcap area. So we're gonna first start with private company questions. And last year at this conference, we talked about Reg A plus a lot. That was the new trend. Where's it gonna go? What's gonna happen? It was all crystal ball at that time. We have a year of experience, and we have a lot of folks on the panel have a year of experience on this. Lou, tell me a little bit about what you've been seeing. Well, actually, I'll start with Laz, because first, explain to the group what is a Reg A plus offering? Who does it fit for as a private company?
Okay, a Reg A plus is fit for companies. Its offerings up to either, well, there's two tiers of Reg A plus, but it is designed for a public company that's looking to raise capital. So it's for any public company and you know, that's looking to raise capital. So it could be anybody, but really it's on the investor side. The idea on this offering is it's a short-circuited process rather than a Form S1, and we've seen over the course of the year where the Reg A process has gotten a sort of accelerated approach of review from the SEC.
Now, I remember, Lou, and this is why I paused, we'll come back to you. A year ago, there were a bunch of people on panels saying, you can do a Reg A plus offering all in for $100,000. Your accountants, your auditors, the platforms, so you've got some experience under your belt. What do you think realistically are more the costs? And two, how does a private company that's in an R&D stage or barely surviving find the money for that?
Yeah, so I think the costs depend a lot on what your marketing budget is, because that's a huge piece of it. It also depends on whether you're going to bring in a placement agent or not. So there's different components to the cost. It certainly should cost less than an IPO. I think if you had $300,000, that would be a good number to cover all the costs leading up to the Reg A offering. There's different groups out there that are providing bridge funding for Reg A offerings. If you know, there's a group that I've worked with that will do a convertible note that leads into a Reg A, and you know, the terms are not great. I can tell you that. It's basically it converts at a pretty steep discount, 30+%. It's going to have double-digit interest. You know, there might be penalties if you don't get your Reg A qualified by a certain time. You know, all the bells and whistles that the PIPE investors would typically put on a PIPE deal, they've now put into these convertible notes. There's another group out there called Serenity Capital that's been taking a merchant lending approach to financing the costs of a Reg A offering, and it's kind of interesting. So if you need $300,000, you know, what they'll do is they'll buy future receivables from you. So it's not technically a loan. So they'll say, all right, we'll buy $600,000 of your future receivables for $300,000. So it's basically 100% interest if you call it a loan, and basically they get the first money out of the financing, and then they also have a right to your other receivables to the extent you have any. So it's you know, it's expensive money. The other thing I've been seeing a lot of companies do, and I'm really a big fan of, is leveraging Title III and regulation crowdfunding to raise capital to then go to a Reg A offering, or doing a Title III, which is equity crowdfunding plus a 506C private placement. You can do them at the same time to raise money for equity for a Reg A offering. And so I don't know how familiar people are with equity crowdfunding, but the rules went effective just last year, so it's really, really new. And you could raise up to $1 million. You have to file a Form C, which is an offering statement with the SEC. It kind of looks like a private placement memorandum, but it's shorter. The SEC doesn't review it, so you file it. And then you could post it on there's about 15 now qualified portals. You put your video up there, you put other information, pictures, you put your Form C information. And then you could start advertising and driving traffic to the portal and take in money from both accredited and non-accredited investors and raise up to $1 million. So it's small amounts from a lot of different people. And it's a great way to raise that $300, $400, up to $1 million that you might need to cover your expenses in a Reg A offering.
Let's talk a little bit about the pitfalls in this area that you might see. So some of you may have folks approaching you for this this new approved crowdfunding Title III approach. Others may say, hey, come and do a traditional 506B. I've got a list you can buy. So a lot of you will have the list of accredited investors you can buy from somebody for $5,000, $15,000, $30,000. You'll hear about that. Lance, I know you've had to advise clients about this a lot. What are the things they should think about or diligence in these approaches?
I found that when the Jobs Act was first proposed, I wrote an article for Shelley, and I said, this is probably the greatest thing that has happened since Reg D itself in 1980. So maybe I take a somewhat contrary view, or maybe I've been in the trenches for the last couple of years. I'm looking at all of the Jobs Act. Equity crowdfunding, general solicitation and private placements, whether you're private doing that or public doing that. You can be public or private and do what we call 506C. And if you're private and doing Reg A+. I think the statistics that the SEC is compiling, the anecdotes that attorneys up on the panel, some of the attorneys I recognize in the audience who are very active in this space, I think we all are anecdotally having a similar experience, which is the Jobs Act is not a revolution. It's an evolution at best. And while it presents new opportunities, it presents new challenges. For example, the last few 506C offerings that we've done have involved, and I'm not knocking anybody, but if you think that there are a lot of people you have to put into your team to go public, I was surprised, my first 506C, I'm no longer surprised. You will have perhaps the investment banker if the client chooses to use one. They're going to want to use some platform. The platform, if you've got an investment banker, and the platform will require an escrow agent, and anyone who's tried to find an escrow agent for a small deal these days knows it's virtually impossible to get an escrow agent. So some of the platforms have tied an escrow agency service to that. They may or may not require a transfer agent, and we're talking about small companies. We're talking about very small companies. I'm not talking about large companies, doing an offering. Then someone has to design the web platform. This is before the invest button, if you will, where you would find the video, the PowerPoint, before you screen and get through to the back. And if it's a 506C, different platforms do it differently. My point is, by the time you put all these people together, and you've got at least 3 sets of lawyers now, right? You've got lawyers for the platform, you've got lawyers for the escrow agent, you've got lawyers for the investment banker, you've got the company's lawyer. I am amazed at the amount of time and the amount of money that it's taking relative to what one is getting out of it. And so I'm not knocking 506C. I'm simply saying that before one looks at that, I'm saying as one looks at that, I think we can understand some of the SEC statistics, which have said that through the end of last year, only about 12 to 15% of dollar volume raised in Reg D and 506 offerings has been the new 506C. The vast majority continues to be the traditional 506B way. Not every company can do that. I'm simply saying that 506C has not proved to be the panacea in private offering that maybe last year or 2 years ago we thought it could be.
So I know that our panel is throwing out a lot of terms such as Jobs Act 506B, C, there'll be even more terms. And one of the things that for companies who are sitting in the audience to think about is my banker is coming to me, or somebody is coming to me to say they can help me raise money. And they typically are going to be pointing you towards the thing they are most comfortable with and the way to raise it. So having some other people helping, counseling you, talking to you, and making sure you understand the pitfalls, the costs, all the different things, and all the other tools that might be in your toolkit that you have not even thought of yet. It's important to do that because there are a lot of folks out there, and it might work for X, Y, and Z company, but it may not work for your ABC company. So you need to really make sure you're getting some advice from someone who is, and there's some great bankers out there who are able to do it all that we know.
Yeah, I think part of what Lance is saying is the worst case scenario. I think, and it happens a lot, but I think that you could also do it efficiently. I mean, you could either do it with or without a placement agent. If you choose to do it without a placement agent, you could put up a page on your own website and collect indications of interest there. I mean, I'm a big fan of using the placement agents because I think they add a lot of value to the deal, and especially if you are generating a lot of leads, to have a group that has a lot of registered reps who can, call up those leads and convert them into investors. I mean, that's the ideal situation, but you do have to be careful. You could end up with many different things that you don't need, or go down a bunch of paths and then have to turn around and waste a lot of money.
No, I don't disagree with you, but so let's just say, for example, a company decides that they're going to try to run an offering themselves. Well, most entrepreneurs, most management teams don't have any experience, and probably a few of them have one person with a little bit of experience of really raising capital. So that presents just a challenge. It's also very time consuming. What people who are offering, whether they're doing a registered direct offering, which is one way to go public, or they're trying to do an offering online or traditionally themselves, it kind of reminds me of the affinity group offerings that we had a long time ago. There's one of my colleagues is in the audience. She and I together worked on an infamous offering, and it was not so easy to see management try to run their own offering, and then you can do only so much because of your abilities, your contacts. You've got to run your business. I agree with Lou that you really you'll benefit from working with a placement agent, and I think Margaret's spot on. Understand that placement agents, because of the way they have developed their business, there are certain types of investors that they are most comfortable with. Those investors and those firms are comfortable with certain kinds of deal structures. And somewhere along the line, and hopefully it'll be one or more of your other professional advisors, as well as your banker, to be able to sit down with you and say, look, it is almost a cafeteria, or it's just a big menu. And some things may look appetizing and they may not be good for you, or you may not be able to afford them. So you really need to keep an open mind, and it's helpful for your advisors to be able to be flexible as well. If they can't be and they try to force you into certain constructs that aren't right for you, there's nothing wrong in taking a step back and just looking at alternatives, and that's really all I'm.
Yeah, so I'm gonna just maybe jump in on this theme about, what is the right exemption type of offering? What's the right one to use at the right time? And I think we all have a consensus here about, listening to an investment advisor, and then getting competent counsel to help evaluate the right mechanism to effectuate a fundraising. Because there are, like you call it, a cafeteria. It's a great analogy, because there's going to be a lot of things on that table that are going to be right for those circumstances. It's going to, the type of offering, whether it's a Reg A offering for a private company or a public company that's appropriate, 506C, whatever the numerical or name is, it's going to be dependent upon lots of factors. the investment banker, the quality, the strength of the company, the interest in the company, the type of investor, whether it's a hedge fund. So there are variables that will be evaluated, and the idea is to really seek out, and I know this may sound like a sales pitch, but you do have to get counsel and have to evaluate all the options with both the investment advisor and your professional counsel that understand these alternatives.
Well, we've talked a bit about how private companies can go public, but one area that we haven't touched on, before Reg A Plus, the big trend that everyone was dealing with was reverse mergers, and that's where a private company becomes public by going into reverse merging into an existing public company. Typically, those public companies were what we call shell companies. They had no operating assets for, they may have been public, but business failed. They managed to keep themselves current somehow with the SEC, and you can see them sold online even to this day. You can buy one for $200,000-$300,000 and become public that way. So that was a trend, and that's something that any conference you go to seems to be a frowned upon trend to use. But we're seeing something a little different now, where we have companies that are public, and they might be companies that actually have some cash in them. And following the consolidation trend we talked about earlier, they're looking to buy a very strong private company to add to their product mix. And I call it, reverse M&A merger. It's a reverse M&A into a operating company. A lot of them tend to be in the life sciences area, that they have a trial that the results came out that were poor, but they managed to raise a lot of money before, and they might have $15 million sitting on the books. So they hire a banker to go out and look for some private companies that might be having trouble raising money. I know, Lance, you've been seeing this a little bit out there as well.
Yeah, we've actually, for some reason, we have several of these right now. These are, as Margaret said, they're all actual operating public companies. One did it as a reverse merger 10 years ago. One did it organically, and I think the third one did its reverse relatively recently, just within the last few years. But they're all operating at different levels. One's tech, one is life science, and the other one is traditional healthcare. And in each of those three cases, interestingly, there is a larger private company that itself, is thinking about, well, where do we go next? How do we go public? How do we raise money? And in what vehicle would we want to raise money? So since they're larger, they're actually able to attract capital. What they'd like is the public vehicle, or their investors would like the public vehicle, and it's really traditional M&A. So we have right now these three companies. The private companies, I think in two of the cases, not all three, in two of the cases, they have actually turned out to be significant investors, leading to the corporate marriage. In the public company, which has now addressed the public company's capital requirements, and they're on the path to doing a merger. The large private company will go public into something that is secure, has a track record at the SEC, is itself operating in a synergistic business line.
Are these NASDAQ public companies,
One is NASDAQ.
Exchange listed?
One is NASDAQ, and the other two are QB.
I've only worked with NASDAQ companies on it. I'm not sure if the benefit necessarily for a private company for an OTC to do that, unless we have an uplisting following with a CMBO.
Yes, the combined entity will be able to uplist, and so in the other two cases, they'll uplist together with the, and then we're told, or at least the board tells me, or the chairman of the board tells me, the banker's waiting in the wings. So, there's this master calendar. Here's what we're doing on the internal financing, whatever rounds. Here's the march to the M&A, all of the regulatory requirements. The uplist follows that, and then the offering comes in.
Yeah.
On the deals that we've worked on, and we've done both sides of it, representing the private company or representing the public company searching for some new partners, the from the private company perspective, if you're approached with this, you really want to make sure that public company already has a banker on the table, because the real, unless they have cash in the bank, cash sitting there, which is rare. So some of these companies do have a failed trial or some product that's not working out, and they had raised a lot of money. So the board is being very smart and going out there and looking for some different product or service line to bring in. But sometimes they'll have little cash, but they're trying to change the story. But they still have that NASDAQ listing. They might have a really good CFO. Maybe the CEO is not great. You have to really look at that and say, what's the combined story going to look like? And do I have a banker who believes, based on this combined story, that we're going to go out and raise X amount? So we did the Fixius 10X deal 3 years ago, and that was a situation where 10X was almost trading below $1. Its product line wasn't doing really wonderfully, and they searched out a private company that changed the story. We had a banker, though, for the public company online that says, if we do this, I can do a CMPO. We went out and did a CMPO for $60 million for a company that was about to be delisted. So you can have these game changers, but you have to really look carefully at who you're partnering with. And on the other end, if you're a public company looking for this, you have to decide, am I at the point where I am really almost a shell company and I have to give away the cow and the milk to make this happen to the private company, with the private company, so you're really getting 0% valuation for your company? Yeah. Or are you still fairly strong, you're looking to consolidate to buy something, so you could really have a good negotiation over that term sheet and who's going to be the CEO and what percent of the company are they going to get. But we are seeing a lot more of this. We are going to go off into Q&A land already, and we haven't even gotten to public companies yet. Are there questions out there for the panel? Shelley always has one.
Well, do you want to do some public? You want to go through some public stuff first before you
Okay. So let's go into public companies. So we had terms like pipes and CMPOs, and we heard about the dreaded toxic convertible notes and debt on your balance sheet earlier. So Lou, most companies that are trading below $2 have some sort of debt, have something like that. What are you seeing in financing trends for those public companies right now, already public companies?
Well, I have an exclusive for the conference. Shelley will appreciate this. Some of you guys may know the name Halter Financial. It's a group. They've been a service provider, provided shells back in the RTO day. They came up with a really neat new concept called an ARTO, an alternative to a reverse takeover. And it's really interesting because it eliminates two of the problems that happen with traditional reverse mergers, which is, one, you have to wait a year under the seasoning requirements unless you do an underwritten offering for $40 million before you can go and uplist to an exchange. And two, you're subject to what's called Rule 144, if you've ever been a shell, 144.1, which if you stop reporting, then it's very hard to get legends removed from your shares, just to keep it simple. And so what the guys at Halter came up with is, through the bankruptcy process, they have a separate bankrupt entity going through the bankruptcy process, and they get authorized by the bankruptcy court to bring in an issuer who will issue shares to the creditors in the bankruptcy. So basically, the issuer issues shares to like 100, 200, 300 people who are creditors of this bankrupt entity, pursuant to an agreement that's approved by the bankruptcy court. And so those shares are actually free trading under I forget the name of the section of the code now, but there's a code section that says if you issue shares in a bankruptcy proceeding as blessed by a court, then it's free trading stock. Lance will stick up for me here. And so basically at the end of this process, you have an issuer who's issued shares. They now have 300 shareholders. The shares are free trading. They can file either a Form 10 or, if they're a foreign private issuer, a 20F, and they can get a market maker to help them file a 211, get a symbol, and they can go onto the bulletin board. They've never been a shell. And they can immediately uplist, or they can, if they meet the requirements, they don't have to go on the bulletin board. They can go straight to the to NASDAQ. When I say bulletin board, I mean OTCQB, OTCQX. But so I thought that was a really interesting concept, and we're actually working on our first one with those guys.
And other folks, what are we seeing in the trends for financing for public companies out there? Where are they finding the money? Where is it coming in from? And what forms are we seeing for 2017?
Well, we're doing a considerable amount of convertible debt. Pipe transactions, the traditional pipe transactions are very active, in stock sales and warrant coverage and the like. But we represent numerous investors, hedge funds, family offices, and they're doing a significant amount of convertible debt.
Yeah, our previous panel didn't like debt, but when we're representing the investors, the family offices, and the funds, we love debt.
Yes. Well, I wouldn't say we love debt. Convertible debt and the toxic convertible debt, so you have a whole layer of financings you go to until you get to that level. And what you'll find with the convertible debt, and it depends on where you're getting that debt from and what the terms are, but they will wreak havoc on your stock price, drive it down. You'll end up with, billion shares outstanding. Yes, you will have to be forced into reverse stock splits just to clean up your cap table. So it's that point. There are points with clients where I say that to them, we're now at the point where this is the only thing we can get to keep you going.
That's right.
But I've had clients that we've done that and we've gone through that and they've they've come out the other side of it. So it does not mean the end, but it is really, I would say, sort of the last place you want to go if you're publicly traded, because you've got to be prepared of what will happen. And the funds out there, you got to read their documents because they will say a lot of things to you about how we believe in a long-term relationship, etc. But read their documents and what they can do under those documents for you. So why don't we open it up now to the Q&A? Yes.
Under the Reg A Plus, where you have an audit going, what's typically the time frame for the SEC to come back with the first round of comments? How extensive have they been in your experience, and how long has it taken to get the whole thing?
All right, let me repeat so everyone can hear that. It's really just what is the time frame for a Reg A Plus offering, and what should we expect from the SEC in terms of turnaround and comments?
I'll take that one. So it's a great question. What we're seeing is an acceleration in the process, a significant acceleration. So I can probably tell you that the total time frame, beginning to end, from filing the registration statement to approval, is about 90 to 120 days. But more importantly, we're seeing a significant reduction in the number of comments, probably almost tenfold in the number of comments. And that's how you gauge how long it's going to take. And the SEC will go through your documents and comment and give you a number of comments. So it's a significant reduction and an accelerated process. And again, this is with good counsel, understanding what the requirements are, and these are the type of Reg A Plus offerings that we're doing are the Tier 2 that include a Form S1 type disclosure, which is the sort of like a 10K full-blown registration statement.
How soon are they getting the first round of comments back?
Those are coming back within the 20 to 30 days, yeah.
SEC's following their internal guideline of 30 days, and I agree. I think anecdotally 120, and I think even the SEC's year-end report said, what was it, 121, 122? So I think our experience is probably right in line with what the SEC is claiming the statistics are for filing to qualification.
And we've done some, and have pending some very unusual Reg A pluses. I would suggest that if you're traditional, fitting into the mold of a traditional company, that time frame works. If you have anything that you think is going to cause questions with the SEC, you call them up ahead of time before you file, and you start talking it through with them ahead of time to work through what those issues might be. So that can clear up your time frame. Other questions? Shelley?
In this world of one size doesn't fit all, in the world of companies trying to raise money, you said in the beginning that it's not only about the lawyering, it's also about the finance. So if I put my hat on, the hat of the CEO of a private company trying to go public or trying to how about, I don't know that, and I'm coming to a law firm that's going to either have a blueprint for how they think it should be done. How open are you to not necessarily putting me on one track or another, but being able to go over all of the possibilities, including going public on the CSE or the TSXV, because we can't leave that out of this discussion. So my question is, what do you say to a CEO who doesn't really know what the heck he wants to do? He knows two things. He wants to keep financing his company, he wants to grow it, and last but not least, he wants to see himself get rich and take care of his shareholders. That's my question.
So the litigator in me says, objection, compound question, Shelley. There are about 72 questions in that. So the basic question is, who are, I'm trying to rephrase this, how do we advise clients who are coming to us, and they may already have a blueprint coming to us, or we might have the blueprint coming to us. So how do we work with those clients to make sure they know that there are probably 25 blueprints for them to look at, and helping them figure out how to pick out the right one that's going to get them to that next stage?
I could take a crack at that if you want. I think you lead with the money. I think when the client comes to you, you figure out which of your contacts you could introduce the client to that's going to result in the most likely chance for them to get money, and that's the route you take. You definitely want to tell them what all the options are, but I think the money is what they're looking for. So if you could find them the money and you do that kind of deal.
Yeah, I'm just going to follow up with that, because I think I mentioned that it's very consistent with my earlier comment about, you know, the form of the offering, whether it's a Reg A plus or a private offering. None of that really matters. It's a question of what the investor is going to dictate and how you're going to get to that investor. So whether it's an investment banker that's already going to tell you how they're going to want their investment, or if you're going to look out and market it. But to answer your question kind of globally, is every situation is evaluated based on the circumstances of the client. Do they have a source of financing? Do they not have a source of financing? Are they looking for a means to sort of introduce their company to the market? And that's what Reg A is all about, by the way. That's the big appeal of Reg A, and this is the ability to go to the market and test the waters. So there's a lot of alternatives, but if the client has a source of funds, that's number one, the easy one, and if not, it becomes more difficult to begin to evaluate how do you try to approach or search for, and that's the harder question, how does a client search for and introduce their company for financing? That's where the Reg A has become very popular over the past year.
Okay, gentleman in the back, brown jacket.
Yeah, we know, timing is everything with respect to financings. Can you kind of walk through the NASDAQ 20% rule, and how that comes into play with respect to the company's timeline and roadmap for financing?
Sure. So the question is, and this is NASDAQ company focused, there is a rule about called the 20% rule related to shareholder approval of certain financings and the timing of that. And there are lots of different structures that you can work to avoid it and get some money in. As someone from the panel, give an opportunity.
No, that's this is your
The
favorite
20%,
area.
the 20% rule. So there's
Well, NASDAQ is
yes,
your sweet spot.
So for NASDAQ companies, there are two rules you have to really focus on. One's the 20% rule, but there's a lesser one that folks forget about, which is the change in control, facts and circumstances one. So you have to look at both of those because you may be getting yourself okay on the 20% rule and not having to go for a shareholder vote. 20% means, are you issuing more than 20% of your outstanding? And if so, you have to get shareholder approval. So lots of ways to structure that. You can get money in up front by saying 19.9% comes in now, and then we have the rest contingent, and we go into shareholder approval. There are lots of legal I's and T's that you need to dot in that area, so be very careful with that. In the but if you're going over, if you're having issues where you're going, maybe you have a 40% issue, so you get 19.9, but then you're going to go to a shareholder vote for 40%. Now we've got NASDAQ, which may require you to do a new listing application because they have a change of control. You have to look at facts and circumstances, not based just on percent. It's who's coming in, how many board seats are they getting, what kind of control are they getting over the company? Is your fundamental business changing? And this happens a lot in the M&A area that we were talking about earlier. So if you are merging with another company and you're issuing stock to the CEO of that company or other people, venture capital, this is an area where you have to focus on that a lot, because as a NASDAQ company, you need to make sure that you actually will meet those relisting requirements. That you initially did years ago. So there are a lot of things in that area to think through, but there's so many ways to thread the needle on it. There was another gentleman who had a question. Yes, sir.
Quick question for Lou. Lou, that's the first time I've heard of an ultra model.
Uh-huh.
And do you see third parties buying discounted debt from the creditor prior to the trustee issuing the stock? And then what kind of valuations you put on, how they come up with it? And lastly, how do the trustees understand this?
So, are you gonna?
Yeah, let me rephrase that. So in a bankruptcy area, when you're dealing with a company using bankruptcy to restructure, so you're not going to bankruptcy and the company is disappearing. You're using it to restructure. What do you do? What can you do beforehand with selling some of that debt off prior to it? How is the trustee going to react to that as well?
Yeah, so, and I'm not fully vetted on the bankruptcy side. That's not my area, but I'll try my best to answer the question. The issuer that we're taking public is signing a contract with the bankrupt entity. So the issuer has nothing to do with the bankruptcy except that it's signing this contract that's requiring it to issue securities as part of the plan of bankruptcy to the creditors of the bankrupt entity. So, and then it gets the benefit of being free trading and all that stuff. So it really doesn't have to do with the securities of the bankrupt entity at all. It's a totally separate entity. It's just somehow Halter, with its bankruptcy attorney, they came up with this plan that looks like it's going to work. We're working on our first one, so call me in 4 months and I'll let you know if it worked or not. But I think it's really interesting because it gives you the benefit of being a public company in an alternative way without having the stigma of a shell associated with it. In terms of valuation, at least on the one deal that we're working on now, I think the issuer is just issuing 5%, which I guess it depends on what valuation you give the issuer, whether that's a lot or not. But I'm trying to think. I think the issuer is doing like $10 million a year in revenue, so it's not a huge company, and they're giving up 5% to those creditors in the bankruptcy. So just to give you some idea of what the valuation would be.
There are a lot of creative things happening in bankruptcy. I think a lot what your question went to was probably more debtor in possession or DIP financing sort of bankruptcy approach. And I would say I don't think anyone on the panel would put themselves out there as doing a lot of that. I typically refer to someone in the state, because bankruptcy law is driven by the state law. It's not driven by federal law. There's some that applies, but the state law. So you need to find somebody in the state where either you're headquartered or incorporated, because you can do bankruptcy filings in either state. And you also need to find someone, though, who, if you're doing debtor in possession financing, actually understands that. There are a lot of bankruptcy attorneys who just do your straight old bankruptcy, or they may have done one DIP. Really try to find someone who's done multiple DIP financings, because they know how to structure, they know how to negotiate discounts out on the debt and get a pretty good deal. And it's painful if you haven't figured that out. Lulu, I'm getting cut off. We're done. Thank you everyone for listening, and thank you panel for this.
Thanks.